This is Richard Keat, Arizona estate planning attorney, and I want to talk to parents of minor children in Arizona. That's children who are under age 18. They're considered minors. Now, there's two important considerations that you as a parent of a minor need to remember. If you were to die and your minor child inherits your assets, the child legally can't own and control those assets because the child is a minor. So a conservator needs to be appointed who has a designation of a court, a superior court, that person is responsible for managing the assets of the minor child. Then that person is responsible and can be legally sued if they make bad investments or cause a loss of the assets. So make sure you have a designated conservator for your minor children if you have assets that are going to inherit if you die. Now, the other issue is who's going to raise your minor children if you die and their other parent dies. So the way you designate who's going to raise your children is you have a last will and testament that designates that if you die and the other parent dies, if there is another parent, then you designate the person who's first in line to be the guardian, and you can have a second in line or a third in line. And you do the same with the conservatorship. You designate in your will who's going to be the conservator and manage the assets of the minor child. Now, the same person could be guardian and conservator, but don't forget that when your minor child reaches 18, then at that time the conservator has to transfer all the assets to the minor child, and the guardianship ceases. Now, we had a sad scenario once where a woman came to us and she had gotten a divorce, and the divorce provided that her ex-husband would have $1 million of life insurance, and the beneficiary that life insurance money was going to be used to raise their child. Well, the man died when the young child was 7 years old, and he did have $1 million life insurance policy. But unfortunately, the policy provided that the beneficiary was the 7-year-old girl. So under Arizona law, she couldn't legally own the $1 million. So the mother had to apply to court to get appointed as a conservator to deal with the money. But the bigger problem was that's not the mother's money. The mother has an obligation to raise the 7-year-old, and the mother can't take the child's money and use it to pay the expenses of raising the child. So what the family should have done is when they got divorced, they should have created a trust, and they should have had that life insurance go into the trust, and the mother could have been the trustee, and she could have managed that money, and she could have used it for the benefit of raising the child. So, but the bottom line is, if you have minor children, make sure you designate in your will who's going to be the guardian and who's going to be the conservator. If you do have minor children or even adults, one of the things that you should consider doing if you've got significant assets is to create a trust that's going to hold those assets for the benefit of your children. There's two ways you leave assets to your children. One is outright with no asset protection and no control. And the other way is inside a trust where you can designate somebody who you have confidence and trust in who's going to manage the assets for the child. Or if the child is old enough and wise enough, you can name the child as the beneficiary to manage their inherited assets. Bottom line is, it's better to leave money to an asset protected, irrevocable trust to your children, whether they're adults or minors, because now they have asset protection. If they get sued, creditor can't get the money, or if the child gets married and divorced, ex-spouse can't get it, or if the child files bankruptcy, the bankruptcy can't get the money in the trust because the trust owns the money, the child doesn't own the money. That's why it's protected from the child's creditors, ex-spouses, and bankruptcy court. One of the recommendations that we make to our clients who have children, especially adult children, is that even though their children may not have significant assets that would justify having a will or a trust, we do recommend that their adult children, have a healthcare power of attorney, because that's a document where the child is going to say if the child can't make medical decisions, then the parent is authorized to make those medical decisions. The child should have a health or a financial power of attorney where it says that if the child is mentally incapacitated, the parents have the power to deal with the child's financial affairs so they can write checks on the child's checking account. And then the child should have a living will. Then a HIPAA authorization goes with the healthcare power of attorney, and the child should have one of those. So those are important ancillary documents that are included in all estate plans that we do, but they're also important for young children because, I mean, it's a terrible thing if your child is in the hospital and unconscious, can't communicate with the doctor, and the doctor doesn't know who to talk to about what care or what, should to operate or not operate on. Doctor needs to know who has the power to make medical decisions for that child. So those are the documents that we recommend that all young people get. And it's a good thing for parents to pay for, have their young children have those documents. One of the things that I love about being an estate planning attorney is not only can we help protect our clients, but I get to work with my son. He does the same type of law I do, which is primarily estate planning. So here we are as two estate planning attorneys. We do have estate plans. We both create them. We're a family business. My wife does the bookkeeping. She used to be a legal assistant for me, but she's kind of retired from that now. In fact, I have one daughter. My youngest daughter worked for me as a legal assistant for 6 years. And then we have Cody, our office dog, which belongs to Ricky, and so he's in the family too. You want to protect your family, we definitely recommend that you adopt an estate plan. We'd love to have a free consultation with you, and you can book a free phone call in office or Zoom conference to talk about wills and trusts and estate planning and answer your questions. And no obligation. If you want to move forward, great. Or if you don't want to move forward after that meeting, that's fine too. It's time to take action. It's very common for people to procrastinate, but bad things happen when people procrastinate. So hope to see you soon.